All right, good afternoon, everybody. I'm Judge Taylor, and I'm covering the case of Billy Bennett Adams this afternoon. The state has filed the motion for pretrial detention, which my understanding is that the defense does not contest. Is that correct?
We're not contesting it, no.
Okay, so just so the record's clear, I will find that the defendant does pose a threat of harm to the community because of what the defendant is currently charged with. And I also find that there's no conditions of release that are reasonably sufficient to protect the community from the risk of physical harm to persons. Is there anything else I need to add?
No, not right now, Your Honor.
Okay. Okay, all right, so Mr. Adams, you will be held without bond on these 2 counts, and not sure what's going to happen afterwards, but as of today, it's no bond on these 2 counts. And so now we're going to go forward on the defendant's motion for protective order.
Yes, ma'am.
Okay. It's your motion. You may proceed.
I'd like to just hand 2 cases to the court and state if I may.
Yes, grab my glasses real quick. Yes, you may proceed. Yes, okay, so I've been asked, Ray, please state your names for the record.
Yes, ma'am. My name is Jamie Kane. I represent Billy Adams. With me also is co-counsel Rocky Brancato.
If you could please, I'm sure the media would like for you to spell both of y'all's last names.
Okay, does this mic amplify? Can everybody hear me okay? Okay, thank you. And I represent Billy Adams. His name is Jamie Kane. With me is co-counsel Rocky Brancato, and Mr. Adams is present in court today. What I've done is I provided to the court.
And Kane is spelled?
Oh, I'm sorry, K-A-N-E.
And for the state?
Teresa Hall represents the state. My spelling of the last name is H-A-L-L.
Thank you. Okay.
All right, thank you, Judge. I provided to the court Florida Freedom Newspapers Incorporated versus McCrary, 497 Southern 2nd, 652, as well as Riley versus State, 557 Southern 2nd, 1365. McCrary is a first DCA case. Riley is a Florida Supreme Court case. What we're asking the court to do is, because of the unusual nature of this case and the procedural, uniqueness, we're asking the court to issue a protective order and to order that no one from the State Attorney's Office, Tampa Police Department, Hillsborough County Sheriff's Office, or the Clerk of Court issue or make any statements or provide any discovery documents or case-related documents to the press or to make any statements about this case to third parties. And I understand that these types of motions don't occur that often, but because of the uniqueness of this case and because of the amount of information that has already made its way into the public domain, we believe that any further information related to this case could certainly impact Mr. Adams' right to a constitutional and fair trial here in Hillsborough County. The more the information that is disseminated, the less likely that the threat of prejudice will dissipate over time and will increase the likelihood that we won't be able to impanel a fair and impartial jury due to the influence of publicity related to this case. I can say that over the past 3 days, People magazine has picked up the story. The Daily Mail in London has picked up the story. The widespread publicity is staggering, and how quickly information has been broadcast. Florida Freedom Newspapers versus McCrary, in that case, the first DCA upheld a gag order related to correctional officers who were charged with crimes in office, so to speak. And in that case, they made it a point to say that they're not trying to restrict public access to the courtroom, just information that is being shared with the public. And for the same reasons that we have already outlined so far in the motion is the reason why the first DCA upheld the trial court's issuance of a temporary protective order, limiting the amount of information and more or less silencing any party involved with access to that information, including the attorneys, pending sequestration of the jury at trial. And what Riley versus State stands for is essentially what happens when that doesn't happen. When the public has access to, say, information that was ultimately suppressed. Like in Riley, the juror, the prospective juror, who was not stricken for cause, was made aware through press documents that a suppression or a confession had occurred, that the defendant, Riley, had confessed. That confession was ultimately excluded, but the impact on the juror was such that when he was not stricken for cause and all peremptories had been exhausted, the Supreme Court said in a death penalty case, no, that juror should have been stricken for cause. And what we have here is an example of what happens when information about a case is allowed to flow freely before an individual is tried fairly. And so what we're asking this court to do is to, in the motion, I've laid out exactly the facts that have been disseminated, in addition to a most recent Fox 13 news article that more or less tracked the motion for pretrial detention. Every fact alleged, whether speculative or whether supposition or opinion, was published by Fox 13 as recently as February 9th, following the filing of the motion for pretrial detention. So, which also includes potentially information that may get suppressed in this case. So we have no guarantees of what the court is going to allow the jury to hear, but what we have here is information flowing freely from the state attorney's office to the press, to the public, some of which is highly speculative, some of which is highly inaccurate. So I'll give you an example. The press has reported that the age of the child inside the car was 18 months or 23 months. So we don't have consistent reporting even on something as simple as the age of the child in the car. We have police speculating on motive, saying that Mr. Adams' motive here was because he didn't want to be a father and he had other romantic interests going on. There is no evidence to support that statement by the police to the press at a press conference, which makes its way to the public, understanding the state doesn't have to prove motive, but that is gossip. So what you have here are the police authorities spreading gossip about motive that is not established in this case. And what that creates in the minds of the jurors is a permanent impression until that threat dissipates. And we're not able to control it. So what we're asking this court to do is to exercise its inherent power to elevate Sixth Amendment rights to a fair trial over First Amendment rights of the press to any disclosure that may exist between the state and the defense. And what we have in Florida Freedom Newspapers versus McCrary is that exact point. Where the first DCA determined that anything short of a protective order silencing the parties, none of these measures would be sufficient to overcome the volume of information subject to dissemination by the respondents and the probable effect of dissemination upon the minds of the public. And what happens is every time, let's say the court denies our motion, every time we have the state of Florida disclosing something to defense under the Freedom of Information Act under Chapter 119, if we engage in discovery and the state discloses something to the defense, the press has a right under Chapter 119 to get that information and do whatever they want with it. That's the First Amendment right they have. If that happens, and we're trying to get a jury, let's say we don't waive speedy trial. If that happens, every time that happens, we have to wait for the threat of that dissemination to fade. As we all know, if something is in the press today, it may not be in the press 6 months from now. But if that is constantly turning over back and forth with information, and the press is constantly sending this information out, keeping up with the progress of the case, we file a motion to suppress. The press gets a hold of it. We file a motion in limine. We take a deposition, and we move based on the contents of that deposition for some relief by the court. The facts of the case are constantly being refreshed in the minds of the public, and we may have to ask for a continuance to wait for that to go away. And they talk about that. A continuance at each dissemination, hoping to dissipate the threat of a prejudice, so as not to adversely affect his right to a fair trial. Because of the unusual nature of this case, because of the swiftness with which he was arrested following an acquittal on double homicide, people have taken a great interest in this case. The first case has nothing to do with the second one, except in terms of timing. And so what we're asking this court to do is to do what is necessary to temporarily minimize the threat of prejudice to his Sixth Amendment rights, grant the motion, and order that each party, whether the clerk's office, state attorney's office, Hillsborough County Sheriff's Office, Tampa Police Department, make no statements to third parties, the press, and to order the clerk not to disseminate or publish any information exchanged between the state and the defense.
Okay, I have a couple of questions.
Yes, ma'am.
So to make sure I understand this. So your main concern is with the accuracy of mainstream media?
No. The main concern is the effect that is having on the minds of the public, who eventually will be jurors in this case.
Well, you gave the example of how old the unborn child was.
Right. Part of that is that in addition to the facts, which may not be in dispute here, the accuracy of the information is also a concern, because we don't control what the press says. We don't control how
Nobody
it's
does.
reported. Right. So when inaccurate information is taken from otherwise accurate reporting, that compounds the potential for prejudice. Meaning that if accurate information is one thing, that's fine. We also don't want any information going out about this case. But the threat of prejudice is increased dramatically when that information is not accurate. So one of the ways we control and prohibit and avoid inaccurate information is to make sure no information gets out.
Well, a couple more follow-up questions on that. Just so that we're clear, I do not, even though I am a judge, I do not have the ability to order mainstream media to be accurate in their reporting.
I understand.
Okay. That's the first question. Second question is, are you familiar with a very big media case that's going on right now as we speak in South Carolina, the Murdoch trials?
No, ma'am, I am not actually familiar with that case at all.
Okay. They didn't press all over nationwide, worldwide press. Speedy wasn't waived, jury's not sequestered. In fact, the rule wasn't even invoked. But if you're not familiar, it's going to be difficult to have a conversation with you about that, so we'll skip that. I would like to say before I move on to the state's response, I mean, I think we can all agree that Florida is certainly not at a lack of media cases. In fact, I want to say that we're probably, if not the number one, probably the number two state as far as trials covered by court TV or mainstream media here. I mean, there's a reason we have those memes called Florida Man, just because we have such notoriety cases here. So I will say, I mean, the media is usually great interest in our Florida cases, and we're usually very open to the press. So with that, I'll turn it over to the state.
Thank you, Your Honor. First of all, I'm not sure that you're fit, not you fit, but the court at this moment is fit to rule on this, because Tampa Police Department, Hillsborough County Sheriff's Office, and the clerk's office were not served notice of this.
Okay.
I got it.
This morning.
This morning, but the other entities that he's asking you to restrict haven't been served notice. So that's the first thing. The second thing is that the court is well aware that Chapter 119 is what allows our broad public access. The
court was formerly board certified in that area before it became a judge. Yes.
All right, and so we have the court. We have media here now. where a lot of states don't allow media to have cameras or any kind of recording equipment in the courtrooms. Florida's not that way. Chapter 119 has exemptions to what can and cannot be disclosed during discovery. We're not to that point. We haven't even had a grand jury to form an indictment yet. So discovery has not went back and forth. Formal discovery has not went back and forth. And even when it does, Chapter 119 has exemptions of what can be and what cannot be shared, including transcripts of a defendant's statement. Those would not go to the media. If there were to be a motion to suppress and those were played in open court, that would be different. Then the media would have access to those documents. Another point I want to make is that the comments made by State Attorney Lopez in a very brief 3-sentence press conference did not violate any ethical obligations, did not violate any rights to a fair trial for the defendant. Ms. Lopez, Honorable Ms. Lopez, did say that we respect the verdict of the jury in the prior case and that we disagreed with it. Otherwise, we would never have prosecuted the case to begin with. If we agreed with the jury, we wouldn't have prosecuted the case to begin with. There is not one single case that we could find that states the state attorney in Florida can't say that. That they can say that they respect the jury's verdict, we may not agree with it. When we go forward with the prosecution on any case and there's a not guilty, we likely don't agree with that verdict, otherwise we wouldn't have prosecuted to begin with. I also want to make sure that the court is aware that this office does everything in its power to assure that every defendant receives a fair trial. We have meetings about it. It is our belief. We did not do anything to violate Professional Rules 4-3.6. We have not done that in any other cases in this office, and we have not done that in this case. We would always want the defendant to have a fair trial. But there is also Chapter 119, not to mention Marcy's Law.
Correct.
I have a right, we have an obligation to talk to third parties, i.e. next of kin. They have a right to know certain things about what's going on. It's written in now into our Constitution. And so if you were to prohibit third-party conversations, then you would also be violating Marcy's Law. Not to mention, we believe you would be violating Chapter 119. We will follow whatever rules this court imposes. We will follow Chapter 119. We will follow the rules of professional responsibility 4-3.6 in this case, as well as every other case we prosecute. But we don't believe that all of the parties have been properly served. And even if you find that you want to go forward, we don't believe that this motion should be granted for the reasons I've cited.
All right, defense?
Yes, I believe what Ms. Hall said is that by granting the motion, you would be in violation of Chapter 119. I would just draw the court's attention to...
I'm not sure that's, I think it was more that Chapter 119 does govern a certain chunk of this case, which everybody's bound by.
And also, one thing I did want to mention is, in reference to the older case, the case that he was acquitted on, 20 CF 13495, that case was closed. It's completely open to public records. And this would not be the courtroom to hear that. If they wanted to not allow some of that to go out, this would not be, Division O would not be the court. It would be the court that it was in, either trial Division 2 or Division B.
Correct.
I don't believe I've made any reference. I'm not asking that the court seal or issue any sort of order related to the earlier case. I would just draw the court's attention to specific language of Florida Freedom Newspapers Incorporated versus McQuarrie. And in that, the court directly addresses the 119 issue. Right where it begins at headnote 3, in the opinion on page 4 of the document that I provided, trial court has the inherent power to control the conduct of the proceedings before it, and it is trial court's responsibility to protect the defendant in a criminal prosecution from inherently prejudicial influences which threaten fairness of his trial and the abrogation of his constitutional rights. It goes on to say, we conclude, based upon the following comments by the court below, that it appropriately struck the balance in favor of the defendant's right to a fair trial under the Sixth Amendment and it quotes the court as saying, the trial court, this court finds that these documents become public records when they are furnished to the defendant. That's true. And the case law is replete, and the Florida statutes are clear. It goes on to say, this court finds and concludes that the constitutional rights of the defendants are controlling over any and all provisions of Chapter 119 Florida statutes pertaining to public records, and this court has the authority pursuant to, and it quotes the discovery rules, to restrict or defer specified disclosures during discovery upon a showing of good cause. So it's not that we take Chapter 119 and we elevate that over constitutional rights to a fair trial. We're asking this court to do a balancing. And we're asking this court to strike the balance in favor of Mr. Adams based on the extensive pretrial publicity that's occurred so far. I'm not saying that the state is incorrect in making reference to its disappointment or its disagreement with the verdict. Where we're drawing the line is where we say that there is some relationship there, and that there is some relationship between those two cases, which ultimately is a legal decision to be decided by this court, whether or not any of those facts or the fact of that acquittal is going to be admissible in relation to some theory by the state that there is a connection there. So we're just simply saying that that's part of the pretrial publicity, is drawing attention to his acquittal 3 days before this death, and that there is some relationship in that acquittal or some relationship in that case to this one. So whether or not those things are going to be presented to a jury is for another court to decide. But in the meantime, making that relationship public creates greater attention on the case.
What
and it makes it
relationship
more
public?
difficult. Ma'am?
The relationship between the first case and the second case?
Yes, ma'am. All right. It's what perpetuates the story as somehow newsworthy. The timing, and then creates a permanent impression on the jury that is a lot more difficult to dissipate or get rid of before a jury's impaneled. Like I said, we don't know if this case is going to take 2 years. We don't know if it's going to take 6 months. We have no idea at this point. But we also, at this point, know that the continued media attention is threatening Mr. Adams' right to a fair trial and is subordinate to Chapter 119 and is subordinate to Marcy's Law. Marcy's Law is not superior to the Sixth Amendment right to a fair trial. And if the court needs to strike that balance, we'd ask the court to strike the balance in favor of Mr. Adams.
How would you suggest the court strike a balance between the defendant's rights and freedom of the press?
That, according to Florida Freedom Newspapers Incorporated versus McQuarrie, in that particular case, similar to this one, Mr. Adams' rights are superior to the right to know.
Superior to what?
The press's
Florida
right to know?
Statute Chapter 119?
Absolutely.
That's what I'm asking. Constitutional right of the press versus your client's constitutional rights. Who wins?
In this particular case, similar to Florida Freedom Newspapers versus McQuarrie, Mr. Adams wins.
Because?
Because there is right now, the court can recognize the inherent threat to his
The court hasn't recognized anything yet, just so the record's clear. But the court could, if it
Yes.
wanted to, find that Mr. Adams' constitutional rights are more important than the freedom of the press?
Absolutely, without question.
Because?
Because the press is not the one facing loss of liberty. The press is not the one facing a potential death sentence. The press is not the one with the constitutional rights to a fair trial. The public does not have a right to know something that is superior to his right to seat a fair and impartial jury. That balance wins every time in favor of the defendant.
I would say that there's some media lawyers out there that represent the press on a daily basis that might disagree with you on that, but okay, I understand where you're coming from. I'm still a little unclear. So Your concern is down the road with picking a jury, whether we will get a fair and impartial jury based on the media coverage.
Based on continuing media coverage. If it is allowed to continue, that will pose a serious and imminent threat to the administration of justice. Absolutely.
State?
Your Honor, we believe that all kinds of cases in Florida have media coverage from the beginning throughout for different developments, all the way to the end. And I don't believe that that has affected a fair trial. There are other avenues if, as we go forward, that the defense believes that the defendant won't get a fair trial. There's changes of venue. There's bringing in a sequestering jury once it's picked. There's bringing in jurors from another jurisdiction. There's other remedies. But to do this now, to tell the press they can't talk, I don't know that we can. I think it's premature.
Well, and let's assume that I granted the motion and stopped either side from talking. I have no control over the random YouTuber, the TikTok person, the family, somebody over in the BBC. I mean, I don't have any control over this. I mean, it just kind of is what it is. Okay, so anything else you'd like to say before I vote?
Yes, just to clarify, and I'd like to thank Mr. Roncato for bringing this to my attention. But there's an exemption under Chapter 119, and it states under Chapter 119.071, subparagraph 2, subparagraph E, any information revealing the substance of a confession of a person arrested is exempt from Chapter 119.07 and Section 24A of the state constitution until such time as the criminal case is finally determined by adjudication, dismissal, or other disposition. All right. So right now, as it stands, Temple Police Department has already released the substance of the confession, and that has been published at length through the contents of the state's motion for pretrial detention. So it goes from Temple Police Department revealing the substance of the confession to the state attorney's office, and then the state attorney and Temple Police Department also discussing in a press conference the substance of the confession, and then the state attorney's office filing the motion for pretrial detention, which has gotten hold of by Fox 13, and then tracked almost by paragraph to the public. Now suppose, just as we had in Riley, that confession is suppressed. And we file a motion to suppress the confession. And that because this court has denied our request for a protective order, that motion is then distributed at, or just printed out on the clerk's website by the press, and then they decide to print out and provide a copy of my motion to suppress confession, which, if granted, has already polluted the entire jury pool through public dissemination. That's how damaging this can be. And we don't know whether or not any statement made by Mr. Adams is going to be lawfully admitted into evidence. We don't know that yet. It's just way too early to know. So the only way we can protect the integrity of any suppression or exclusion or motion on our part, and the administration of justice through a fair and impartial voir dire, we're asking this court to grant the motion.
Okay, back to your Chapter 119 for a moment. If you do feel like Tampa Police Department or any other agency has violated Chapter 119, you can file an action against them, and I believe attorney fees are included, so something to think about going forward, just FYI. Right, State?
Your Honor, the only thing I would have to say is I just want to make sure it's on the record. I don't represent Tampa Police Department. I don't represent the Hillsborough County Clerk. We filed our petition. It was made public because it was filed through the clerk's office as we were supposed to file. Tampa Police Department, I don't control them. I don't represent them, and they're not here. They don't even have representation. So I don't believe that you can remedy against them when they don't have a right. They haven't had a right to respond.
No, I understand your point, but
Yeah.
But anything else before I vote?
No, nothing else from the state.
Anything else from the defense?
No.
Okay, so I am, Mr. King, I am going to deny the motion at this point, but it's going to be without prejudice. In case something else comes to light, then you need to rebring it. That's what I'm going to do, it without prejudice, just in case another judge may see it differently going forward. And that said, I'd like to caution all parties in this case to please be aware of Chapter 119 and Marcy's Law and abide accordingly.
Yes, Your Honor.
And I guess with that, we'll be in recess. All right, thank you.